All right, sir. So this is your pairing time complaint. Is that correct?
It is.
And how do you feel your pairing time was violated? The pairing time order was violated.
I was supposed to have the kids the first week of Christmas break, and in text messages, she said that I was not going to get them. Blatantly, I gave up my holiday schedule when we were first going through our divorce. At that time, I was seeking medical treatment, and this time around, I wanted my kids, and she blatantly just withheld the kids from me.
All right. So as holidays, your order says that holiday pairing time is as the two of you agree. If no agreement, then you shall default to the standard holiday guideline. Is that correct?
That is correct.
All right. And based on that holiday guideline, it was your understanding that you had first half of the break. Is that correct?
That is correct. And with them not having school on December 19th from a snow day, that was my weekend anyway, so it should have just kept rolling till I believe December 25th at nighttime or on the 26th.
Okay. Did you have them on the 19th?
I did, Your Honor.
All right. Why didn't you just keep the children then if the court order said they were yours?
She has blatantly threatened me, and I have text messages of her just saying she's going to take the kids, and it's pretty much what she says it goes. And she didn't believe that there was a state appointed holiday schedule.
So how did the children go from, so you had them for that weekend, and how did they go from you to her?
We met at the across the state post in Gaylord at 1 p.m. on Sunday.
All right. Well, I mean, if those are the facts, I'm not going to find her in contempt. The children were in your care. The order said they should still be in your care, and you gave them to her because she told you she wasn't agreeing, but the court order is what controls. So she didn't prevent you from having the children. You voluntarily gave them back to her because they were in your care. It'd be different if she took them from you or didn't send them to you. But it sounds like you had them. She told you, hey, you can't continue to have them, but you relinquished to that demand, which was contrary to the court order. So I'm not going to find her in contempt. I would just indicate to you that in the future, if you have the children and it's your time, and no matter what she says, it's the court order is what controls. Do you understand that?
Do, Your Honor.
All right. All right. Thank you for appearing. You're all set for today. I will dismiss the contempt against Ms. St. Clair. Thank you. You're all set, sir.
Thank you.
All right. This is your objection to a child support recommendation. What is the basis of your objection?
When we had court back in October for custody, I guess I didn't realize what it was going to entail when I agreed to 50-50. But when I got the child support recommendation that I was to pay child support, I just did not agree with that.
All right. I'm looking at a recommendation that has support at 0. Is that correct, front of the court?
That is.
So, ma'am, you believe you're supposed to pay support?
I had gotten a letter in the mail for $168 it was showing. Maybe I was confused on that, but or at least I took it that the 168 was what I would be paying. And that's just what confused me.
Front of the court, do you know anything about the 168 figure?
Well, there was an order in October that the parties agreed to deviate to medical cost only. So part of that may include what support was with the deviation. I don't have the recommendation in front of me, but it does indicate that she would have been responsible for the medical grant or the repayment of the medical grant. 2 factors, she's a recipient of the grant and the amount was less than $20. So with that, it was just B0.
And I do see that. So there is a deviation addendum. So you guys agreed to do something different. So if you hadn't done something different, it would be the 168. But you guys, because you had the agreement, it's actually 0. Does that make sense to you, ma'am? So anytime you make a change to the standard guideline, we have to show what the standard guideline would have been and then what we are actually doing. So the 168 would be if you guys had not had an agreement, but because you have the agreement, it's actually 0. Does that make sense?
It does, but I think I'm still confused. Now,
Well, you
when
don't
I
know what
was
he's-
just, if that was the case, then I'm okay with that. When
Okay.
I was looking over the, with the 50/50, when I was just looking at the papers and it had said that we had the same amount of overnights in that. That is absolutely not true. And Callie is just in my care more than full time. So I just wanted to be sure. And when I got that letter, it just drew red flags to me.
And that number doesn't certainly dictate what your guys' actual agreement is, because isn't your agreement just as the parties agree? Is that correct?
I believe so.
Okay.
That 168, it threw me off that I was gonna have to pay in that.
Sure.
I was just
No.
confused.
You do not have to pay. Is that correct, front of court?
Correct.
All right. So knowing that you don't have to pay, do you want to withdraw your objection and it'll simply just be at the 0?
Yes. Yep,
Okay.
if that is the case, then yes.
Okay. Mr. Hall, anything you'd like to say?
Yeah, would you clarify what the 50/50 is as far as visitation for me?
There's nothing I can clarify because your guys' agreement is as the parties agree, is my understanding.
Well, yeah, it was supposed to be 158 nights, and she is supposed to have 158 nights. So it's 50/50 on there.
No, so what controls what you guys are doing as far as pairing time is your order. You guys have an order that says you have joint legal, joint physical, parenting time as the parties agree.
So how do I go about, like, if she won't let me see my daughter and stuff like that, or how do I get that set up?
You'd have to file a motion for parenting time. You can file a motion to request specific parenting time schedule if you guys can't agree to one. But right now, the order is simply as the parties agree. So if you're not coming to agreements, the next step would be to file a motion.
Okay.
Your Honor,
Yes.
with this objection, if we want to change the parenting time, can I do that with the objection that I filed, or will that be a separate one?
That is a
I
separate
just don't want to
motion.
run into problems in the future with the parenting time and having issues. That would
Yep,
just be a
that's a
separate
sep-
motion. Okay,
That is a separate motion. Either of you wants to establish a specific parenting time schedule, then you got to file a motion.
okay.
All right. Any questions, sir?
Nope, that's it.
Thank you both for appearing. You're all set.
Thank you.
Thank you.
Bye.
We are here today on Mr. Lambert's objection to the child support recommendation. Is that correct, sir?
Yes, sir.
And what is the basis of your objection?
No, it's a 550% increase that I'm still on state probation for the arrears, and boosting it to that amount would obviously put a detrimental hurt on getting it paid off to satisfy the probation. That's the first thing.
All right, so as to the support calculation itself, did you have any objections?
I don't know, because I don't know how it calculates. I mean, like I said, a 550% increase is pretty drastic. So,
Well, when was it last? Looks like it might have not been done since quite some time previously. Well, the last order was 2021. I'm not sure if you had much of an income change since that time or not, but. So you received the recommendation and you went through it. Is there any issues with the calculations that are in the recommendation?
well, I mean, no, the one thing that I see that stands out is, under the adjusted, it's showing a 2611 on her side and a 4864 on mine. And then, given the amount that they want paid, that would boost her up to almost 4,300 and me down to 3,000. I mean, I don't have less obligation here, that she has. I mean, I still have a household and children here. So, you know, $1,000 offset again just seems off. I mean, I guess
Anything else?
Sorry.
Anything else you want to say regarding your objection?
No, I just wanted to see if there was an amount that she's actually looking for, if she's seeking that full amount.
All right, thank you. Ms. Wargo, anything that you would like to say on this matter?
His original order back in 2013, 14, was for $11.21 a month for 3 kids. And then for whatever reason, it was reduced to 300 and something in 2021. So it's not a 550% increase.
All right, so are you asking that the recommendation be adopted?
Unless there's another amount that he wants to agree to.
And that's, I'd like to ask you that, you know, like you said, it was 11 something for 3. We've got 2 now, you know, one's working, you know, she kind of does her own thing. When they need something, they message me and I send them Cash App or Apple Pay or whatever. So, you know, I mean, I'm open to hearing what you want, but I don't feel that the amount on there is a good amount.
So ma'am, is there anything that you want to say?
They have pretty significant costs with orthodontics and dental and stuff that I have not turned into the court to get money back for. So that's all coming out of my pocket.
It's just simple as this. Do you want to agree to a different amount, or are you asking to agree to a different amount, or are you asking that the court adopt the recommended order?
If he has another amount that he would like to propose, we can talk about that.
All right, well, today isn't necessarily negotiation day, but I'll give you a small chance here because we have other cases to see if you guys reach an agreement on a figure that is different than the recommended amount.
What, Selena, what do you think is a fair amount that'll, you know, get you what you need and still, you know, I mean, I know that you're not really trying to consider what I need here, but, you know, kind of considering all things and what you need, where do you need to be? I mean, you know that I do what I do now, and I started from the bottom driving a truck, and I'm not driving a truck anymore because I've worked hard over the last 7 years from home to get to where I'm at. So, you know, I don't feel like just because I've pushed real hard that I need to lose everything and go back to, you know, what I was making when I was driving a truck 8 years ago.
Right, but you have obligations. Like
and I pay them, and
All
I
right,
pay.
so what I'm going to do is I'm going to let you guys, if you guys want to discuss it and agree at some other time, to a different amount. But I'm here to address then the current support recommendation. Mr. Lambert has filed an objection. He indicates he doesn't agree with the amount and that it would be a hardship for him. But there's really no specific objection to the actual calculation and the figures used. Obviously, when there's 0 overnights for a parent, that has an impact on what a final support amount's going to be. So I am going to deny the objection because I don't think there is a basis to indicate that the guidelines figures were not accurately used and imputed. So I will deny the objection. Obviously, the 2 of you are free to talk. If you guys come to an agreement on some other figure, you would have to file a motion or a stipulated order.
So we're not free to talk. I'm not allowed to have contact with her per the orders of my probation.
All right, well, and this doesn't, so today's not set for a chance for you guys to sit and go back and forth. I gave you an opportunity to do it. It was clear you guys weren't getting there today, and I've got other cases scheduled. So again, the basis of your objection, I don't think is, your request to the object is denied because I don't think your request is anything that goes against what is in the child support guideline and formula. There was no objection to how the actual calculation was done, just to the amount that was ultimately ordered. So the objection is denied. You do have a right to object to the decision I just made and have the matter heard before the judge. You have 21 days to file that objection. That information will be provided in the paperwork that is sent to you. All right, thank you both for appearing today. You are all set.
Thank you.
Mr. Saylor, this is your motion regarding the child support, is that correct?
Yes.
And what are you requesting that we change?
Stormy and I have discussed about lowering my child support down to $200 per month. And other factors are being handled between Stormy and I personally.
All right, ma'am, is that correct?
Yes.
All right, do you receive any state assistance, ma'am?
No, we just have Medicaid at the moment.
All right, so that does apply. Was that factored into the support amount?
It should have been.
Okay, all right, so it does look like there is a ordinary medical. So ma'am, is your agreement then, because that has to go, is your agreement to be the 200 plus the $7 for the medical, or $193 to you and then $7 for the medical? You understand that question, ma'am?
Yeah, I was just thinking about it. The 200 and then
That's
the
a separate-
medical.
Pardon?
The 200 and then the medical.
Okay. So you're in agreement with that, ma'am? Would you please raise your right hand, please? The best that you can. Thank you. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. So ma'am, are you asking the court then to deviate on the support amount, and it would be $200 payable to you for support, and then also the $7 in medical? Is that the change that you're asking the court to deviate to?
Yes.
And are you making that decision freely and voluntarily?
Yes.
You understand that the support recommendation would have paid you $440 instead of $200. Do you understand that?
Yes.
And do you believe that with this deviation in support, you can still adequately care for and provide for the child?
Yes.
Okay. So by stipulation then, indicate the parties have agreed to deviate to $200 for the base support to Ms. Skinner, plus the $7 in medical. Front of the court, anything else you think we need to address?
No.
All right, we'll make that change. Thank you both for appearing. You're all set.
Thank you.
Ms. Robinson is here on behalf of Mr. Schultz. And Ms. Robinson, this is your motion, is that correct?
Yes, Your Honor. And in fact, I think the parties have had some productive discussions, and we have a pending resolution to this. So it looks like I can just draft a custody agreement at this point and submit it to the court.
Okay. In general, what are those terms?
In general, those terms would move the minor child to the physical custody of Richard Schultz, and parenting time with mom would be as the parties agreed.
Okay. Ms. Schultz, are you in agreement with that?
Pretty close to it. I was hoping just to drop it out of the courts completely, and then we'll figure it out. Sabine's 16, and while she's doing better, we're working with her. She's top of her class, but she wanted to go online, and she's 16. She wants to spend more time with her dad. So if he's in agreement to drop it completely out of the courts, we're not on any state assistance. That would be wonderful. But if he feels like he needs it in writing, I'm willing to do that too.
All right, well, I think typically it's, if you guys are doing something different than what the last order says, it's good to have it in writing. So they're proposing that essentially he would have the primary physical custody, you would have parenting time as the parties agree. Are you in agreement with that?
Pretty close to it. Yep. We just need to draft it up.
All right, so I'm just gonna take some general then, I'll swear both parties in and just have them put that general agreement on the record. And then Ms. Robinson can follow up with a written agreement with all of the terms. So Ms. Schultz, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
So ma'am, are you in agreement in this change that would grant dad the primary physical custody and then parenting time as the parties agree?
For now, yeah.
All right, and at this time, do you believe that agreement is in the best interest of the child?
Yes.
Thank you. Mr. Schultz, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. Are you asking the court then to enter the stipulation that would grant you the primary physical custody and then parenting time for Ms. Schultz as the parties agree?
Yes, that's correct.
And do you believe that's in the best interest of your child?
Yes, I do.
Right, so then Ms. Robinson, I will leave it to you then to complete the order, fill in all the other terms that the parties agree to, and submit that.
Understood.
All right, thank you everyone for appearing. You're all set.
Brooke Robinson appearing on behalf of Maxwell Orourke.
Ms. Robinson, what is the status of this matter?
It looks like we have made it through mediation. We've got a partial agreement right now. We're agreeing to continue joint legal and agreeing to utilize the AppClose app for ease of communication. The only thing that is not resolved right now is physical custody and parenting time.
Okay. Are you asking for an evidentiary hearing or some additional time to discuss those issues?
I think we should probably go ahead and schedule an evidentiary hearing at this point. I don't know that we're going to be able to make a resolution on this together.
Okay, my next available date is April 8th at 1 p.m. Do you have any conflict with that date?
Let's see. I do not.
All right.
That would
Ma'am, do you
work.
have any issue with?
Can I swipe out of Zoom on my phone to check my calendar? I don't know if it'll close it. I don't know if it'll close this out.
Well, if you leave Zoom, you will, but you can certainly check your phone and you can, stop your video if you need to, if you want to check your phone or whatever you need to check.
Okay, I know I have an appointment in April. I just don't know what day it is. So I just need to check that really quick.
Sure.
Okay. No, I have no conflicts with that date.
All right, so we'll schedule you for April 8th at 1 p.m. That is a in-person hearing. Witness and exhibit list would need to be filed 21 days prior. The child would need to be here at 12:45 for the preference interview. Ma'am, is it correct that you did reach an agreement though at mediation on those other terms as far as joint legal custody? Some other terms that were in there as well as using the app to communicate, is that correct?
We didn't really agree on any terms in there other than to communicate through the app. We
have a written mediation agreement that says otherwise.
And not in terms of custody.
Says you're going to share joint
that
legal
our custody order will continue.
Yes.
Like our current order. So nothing in terms of our custody has changed. Nothing like in terms of custody has been agreed on.
No, we agreed to continue joint legal.
Ma'am, do you understand the difference between physical custody and legal custody?
Yes, I do, Your Honor.
All right, and you're agreeing to continue the joint legal custody?
For now, until this is resolved. And that was my understanding, is that everything would continue as is until we came back to court.
Well, that's not exactly what I see in the mediation agreement. I see that you have these agreements and then it says the issue of physical custody and parenting time is unresolved. Current order as far as custody and parenting time remains the same until it's addressed. But you guys, there's some agreements in here about some communication, like you said, a bedroom issue, not smoking. So you agreed to all those things, correct?
Yes. But in terms of custody, I thought that
correct. Custody is
matters.
not resolved. Custody is not resolved. That's what the purpose of the April 8th hearing will be. So I would indicate that the parties' mediation agreement is adopted, and then the issue of custody and parenting time will be addressed at the April 8th evidentiary hearing. Anything else we need to address today, Ms. Robinson?
No, Your Honor, thank you very much.
All right, ma'am, do you have any questions or anything else you think we need to address today?
I need I need the court to enforce our current parenting time order because Maxwell is not bringing Clara to me when there's no school or snow days during his time, which is in our current court order.
The appropriate steps are if a order is being violated, you file a parenting time complaint, and that kicks off the process then for the front of the court involvement.
Well, that's part of the issue that's in the motion though. And we're using the court app to communicate, which, and from my understanding, the court can read our messages where he has blatantly said, I will not bring her.
Well, the court does not just sit around and monitor the apps. It's just so, you know, if parties come to court, they're free to print those off and let us see them. But if you feel that there's an order that's being violated, the appropriate step, if you want, is to file a parenting time complaint. Obviously, we're going to address any changes and other issues at the April 8th hearing. That's to address custody and parenting time moving forward. If there's a current order that's being violated and you want to address that, you can file a parenting time complaint, okay?
Okay.
All right, thank you everyone for appearing. You're all set. Ms. Thompson, this is your motion regarding custody, is that correct?
Correct.
What are you looking to
And
change?
parenting time. So we currently share joint legal and physical, and it has kind of just been like, it hasn't been working out great. Anthony has recently made it very clear that he does not want anything to do with the children. And I think the back and forth is just taking a very large toll on them, and they just need some stability.
All right, sir, are you in agreement with the change or not in agreement?
Yes, I'll agree to it.
All right, so what would that mean as far as parenting time for dad? That it would just be as the parties agree, or is there some specific parenting time?
No, we definitely need something in place. I thought that every other weekend would be sufficient. I think,
Okay.
but like I said, like most recently, Tony informed me he's not a babysitter, and so I don't know. I guess I would leave that to him if he would like to see the children every other weekend. I think it would be good for the kids, but I will leave that to him.
So, sir, what are your thoughts? And if you guys want to, you can also go to mediation and have a more lengthy discussion regarding specifics of parenting time if you think that might be helpful. What are your thoughts, sir?
We can try that and see where that goes, but
Well, do you want to do every other weekend like she proposed, or do you want to maybe go and have more discussions on what your parenting time would look like?
that's fine. We can do every other weekend.
All right, sounds like her concern is whether or not you're going to exercise that though. So if we're going to make that in order, is that what you're going to do?
Yeah. It's not like I didn't take them every other week.
Okay.
It's
So you could agree to every other weekend, sir?
yeah.
And then what about holidays? Would you guys just do holidays as the two of you agree, or follow a specific holiday schedule?
Before we did every other holiday, major holidays, and I think that would still be beneficial. So like Christmas, Halloween, Easter, Thanksgiving.
Was that based on your own schedule or on the court's standard schedule?
I believe we agreed upon that on our own. I don't know if that's in writing, but that's just what we've always done.
Sirs, what are your thoughts on the holidays? Do you think there should be a specific schedule or just as the two of you agree?
Just how we agree.
Okay. And then is it going to be every other weekend throughout the entire year or something different in the summers?
I'm fine with throughout the entire year. That's
Are you in agreement with that, sir?
Yeah.
Okay. And then, ma'am, you were asking for sole legal custody,
That's correct.
and sir, are you in agreement with that?
Yes.
Okay. All right, I will start with you, ma'am. Well, as far as exchange times and places, do you guys have specifics for that? A place that you typically exchange at, or how do you handle the exchange of the children?
We typically exchange through daycare and school, so it would be Friday to Monday. He can pick them up Friday and drop them back off Monday morning.
Okay. All right, so his weekend would go until Monday morning. Okay.
Yeah.
All right. So ma'am, please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right. So ma'am, is it correct that you're asking the court to enter an order that would grant you the sole legal custody and primary physical custody of the children, and parenting time for dad would be every other weekend throughout the year, as well as holidays as the parties agree? Is that correct?
That's correct.
And during the school year, his weekends would begin after school or daycare on Friday with a return to school or daycare on Monday morning. Is that correct?
Correct.
And then so in the summer, would it just be from daycare and to daycare?
Yeah.
Okay.
Our son typically does a summer program, so it would be the same type of deal.
Okay. And do you believe this agreement is in the best interest of the children?
I do.
Thank you. Sir, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And sir, you also asking the court then to enter this new order granting mom the sole legal custody, the primary physical custody. You would have pairing time every other weekend, Friday until Monday, as well as holiday pairing time as the parties agree. Is that correct?
Yes.
And do you believe this agreement is in the best interest of the children?
Yeah.
And ma'am, are you requesting then that a new child support recommendation be prepared?
I'm not requesting any child support.
Okay. Is there any assistance, any Medicaid or anything like that?
They do currently have Medicaid because our daughter has cancer. But that's it. And I don't know, I believe she's on a special plan because she has cancer, so I don't know if that would.
Qualify or not? Okay.
Right.
We'll have to check that. If there is any assistance, then we could deviate just to the medical only.
Okay.
So it would be a payment. So ma'am, you would agree to that deviation?
Yes.
And are you making that decision freely and voluntarily?
Yes.
Can you adequately provide for the kids without any additional child support payment?
Yes.
Okay. In front of the court, anything else you think we need to address? All right. Thank you both for appearing. You're all set. We will prepare that paperwork.
Thank you.
James Saffel appearing on behalf of Casey Atchison.
All right, thank you. So Mr. Trevor, you have filed a motion to change parenting time. Is that correct?
Yes, I have.
Okay. And then I know, Mr. Saffel, you still have your motion sort of hanging out there with a status conference date because you were waiting on some discovery. Is that correct?
Correct.
And then we also have, it looks like next week, a support objection as well as or not next week, next month, a support objection date and a parenting time complaint show cause date. Is that correct, Mr. Saffel?
I believe that is.
Okay. There's an FOC petition regarding the ability of Mr. Trevor to pay. Is that correct?
That's correct.
So we've got a lot of matters to hear. I mean, my hope would be we could figure out a date to throw all these things together and take all the necessary testimony. Mr. Staffel, do you think you're in a position then to argue these things here coming up in an evidentiary hearing?
Provided discovery is completed. There's discovery still pending from last year, and with Mr. Trevor's most recent assertion, including a letter from Munson Healthcare that he can't work, we certainly want to get some discovery on that issue as well. So it would be my intention to serve him with some discovery with regard to his most recent claim about being incapable of working, and also hopefully persuade him to comply with the discovery from last year. In part, that's the failure to provide his tax returns. But following that, assuming that he does those things, then certainly we would be prepared for a full evidentiary hearing on all the issues, presumably on one date.
So I've got 4 different dates available in April. I think maybe the latest in April would be the safest thing to do.
Yeah, it might be too soon. I haven't served the discovery yet, but I can get that out quickly, certainly in the next week.
Well, Mr. Trevor, I think I think if you're indicating you can't work, then you need to provide that medical proof, certainly to the friend of the court, as well as a copy to the attorney. Do you have any issue with that, sir?
I already have. I had sent Tara the ER and the doctor's letters saying basically I can't work. I actually have a hernia, and then when I was arrested for the child support, I had mentioned to one of the deputies in the jail I had a hernia, and then they made me cough, and it made it made it extremely worse. Had to go to the ER.
Are you able to provide those documents also then to Mr. Saffel?
Yes, I can. And then I was actually supposed to have a hernia surgery yesterday. I had to cancel because I'm actually sick and been sick for the last few days.
All right, so what I'm going to do is set all these things for April 29th at 1 p.m.
That would work, Your Honor.
All right, and that'll also then, the matters that we have coming up for next month, that's the show cause date as well as the child support objection. We'll just hear all those things on April 29th, so you guys don't need to sign back in on March 18th.
Okay.
Any questions regarding that, Mr. Trevor?
No, my only question is, I guess, what do we do about the, it's been like almost 14 months since I've seen Lonnie at Safe Haven on these supervised visitations. I just don't understand what's taking so long. Or, I mean, I know I'm part of the issue on filing, but financially, I really can't keep fighting this battle without funds. And to be honest, I'm on a pay-to-play program with the power company right now. We've been shut off multiple times. I know, big sob story, boo-hoo, but yeah, we're really trying. I mean, I got a 9-month-old that my daughter hasn't even seen, and I think that, frankly, that's the reason why this parenting time was canceled, because I had mentioned it twice at Safe Haven that Lonnie was going to be a big sister. And then after that,
that's what the evidentiary hearing date is for, is to figure out, are there any violations that have taken place, or what should be the path moving forward. Both sides are looking to make changes, so you both have your chance to make those arguments and see where we go there. You also have your opportunities to make your arguments, both sides, regarding what the appropriate child support calculation figures should be. Okay.
Okay.
So don't worry about those March 18th dates. Those are all adjourned. Those hearings will all take place on April 29th at 1 p.m. That is an evidentiary hearing, so that is a in-person hearing.
Your Honor, the April 8 hearing would also be off as well and combined with
Yes.
it. Yeah.
Yes. Now the child's going to be 7 come April 29th, so I would do a preference interview.
No, she should be
Child-
turning 8.
I'm sorry, 8, my math is off. So we would do a preference interview with the child. The child should be here at 12:45 for that preference interview.
And this hearing would be live in the courthouse.
Yes, sir. All right, we'll see everybody back here then in person on April 29th at 1 o'clock to address all issues.
Thank you, Your Honor.
Thank you.
Your Honor, I do have a quick question.
All right, maybe I'll be able to answer, but maybe not. Okay, go ahead.
I was told I had 2 hearings today.
You're good. We're going to address everything on the 29th. But again, if you have other medical records that you want to provide, if you know something new happens, make sure you get those in and give a copy to counsel. Okay.
Yeah. I actually have got some other records for my shoulder that I had mentioned. I had problems with previously. I had a flare-up episode of calcific tendonitis, so I got all the paperwork for that too, and I can send
all set.
copies.
Thank you.
Thank you.
Both parties are present. And Mr. Chidsey, this is your motion regarding parenting time. Is that correct?
That is correct, Your Honor.
All right. And what are you looking to do?
I would like weekends and holidays. Maybe split the holidays if necessary.
Okay. Ms. Day, are you in agreement with that or not in agreement?
She doesn't even know who like he is or whatever. I mean, he can take her on the weekends, but she's not gonna go with him because she doesn't know him.
All right. So what we have to
But like the
decide is,
holidays, I would like to have her on Christmas, and then he can have her on Christmas the same day. Like split it. But we're also trying to work it out, like me and him. I think we're gonna get back together.
all right. So we've got a few different options. You guys can place an agreement on the record today. You guys can ask for an adjournment to see if you can reach an agreement on your own and further discussions and see where things are at. Or you can also ask to participate and have a referral to mediation where you would go and have those discussions with a mediator and see if you can reach an agreement. I mean, if the two of you might be getting back together, maybe the sensible thing is to adjourn this out a little bit, give you guys a chance to talk.
Yeah, that would be better.
Sir, what are your thoughts on that?
I'm in agreement with that, Your Honor.
All right. How much time do you guys want? Do you want, 30 days, 45, 60? What are your thoughts on how much time?
30 days
Your
will
Honor,
be fine.
yeah, Your Honor, I do want the opportunity to get to know the child a little bit better. That basically has been denied up to this point, and she is correct. The child isn't comfortable with me yet, and I really would like to rectify that situation. So I need some time with the child immediately, basically.
You're gonna get
Looks
that
like-
because me and Joe's not together no more, so you can see her.
Looks like we have a hearing on March 11th.
That sounds great to me.
A petition
Yeah,
to
that's fine.
address Mr. Chidsey's income. So why don't we just do both things on that day? So we're going to adjourn this a status conference of this motion to March 11th at 10 a.m. That gives you guys a few weeks to have some discussions and figure things out. When you come back then, you can let me know if you have a specific agreement as far as parenting time or not. And then if you don't, we can either send you guys to mediation or we'd set the matter for a court hearing. Any questions regarding that, Ms. Day?
No, that's fine.
And did you mention a time, Your Honor?
Yes, March 11th at 10 o'clock.
Thank you, Your Honor.
Anything else? All right. Thank you both for appearing. You're all set.
Thank you.
Okay, thanks.